great to welcome you back for another of our series that we're doing on the American Constitution. I'm calling it The Roots of the American Constitution, a bit of a follow-up to the series we just completed this spring, which was entitled Presbyterians in the American Revolution. So I hope that you're finding this a good complement to the material that we already covered in that regard. I did get an interesting response to the last presentation from someone who was really objecting to my statement that the Constitution had its roots in a Christian tradition. And the person indicated, well, if that were the case, then how come the Constitution doesn't command us to love the Lord our God with all our hearts and souls and minds and to love our neighbor as ourselves, that sort of thing? How come it's so conspicuously absent from the Constitution? I thought a remark like that deserves comment at so many different levels. I wasn't quite sure where to begin, but I thought I'd at least just very briefly in a couple of minutes give some kind of preliminary response, because maybe that thought has crossed your mind as well. For one thing, of course, you understand the Constitution was created by the people to control government. And so in a sense, if the Constitution included a command like that, it would be a command addressed to the government to engage in those kinds of Christian behaviors. Whether that's appropriate or not, I'll leave to your own imagination. But maybe more profoundly, the Christian tradition through Calvin, through the Puritans, the Presbyterians, and so on that we've talked about, really did envision that in human society there are three separate, interrelated, but nevertheless distinct realms of sovereign authority. One is the family. The family is a sovereign and sacred space. And in the family, of course, children growing up learn both the aspirational side of life. These are the things we ought to do, but also the restrictive side. These are the things we don't do. The family is a place where we hear both of maximum but also minimum standards, Well, as we move away from the family, we find that there are two distinct authorities out there that do the same thing, sort of extending the principle found in the family. The church, of course, is one of those, and the state is the other. The church is there to call us to the highest possible aspirational goals. Love the Lord your God. That's what we're called to do. Do unto others as you have them do unto you. The message of grace. All of that, of course, is properly within the province of the church, and that's what we should be hearing. Every time we hear a sermon, we should be hearing a call to a higher kind of life. The function of the state is exactly the opposite. The state is there to restrict evil behavior. The state is there not so much to be aspirational as to be restrictive, to say this is the minimum standard of behavior, and if you go beyond that standard, then you're going to be in trouble with the state. Paul himself says to Timothy on one occasion, the law was not given for righteous men, but for sinners. And then he names a bunch, for lawbreakers, to ungodly, for unholy, for those who kill father and mother, for murderers, for adulterers, for perjurers, and so on. He gives quite a list. The law is there for them. Now, the law is instructive to all of us, but the point is it's there to be a restraint on evil. And thus it has a very different purpose from the aspirational behavior of the church, and we should keep those two distinct. Both can be Christian in terms of their roots, and yet their function is quite different, and therefore the content of them will be quite different. And of course, right now we're focusing on the state. We're focusing on this legal system that we've created, which is intended to restrain evil. Of course, the evil that's being restrained here is principally the potential evil of the state itself. That's why we, the people, create the state and put certain restrictions on it to make sure that it doesn't overstep its bounds. So I hope that helps. Anyway, we're going to be picking up right now where we left off a week ago. A week ago, of course, we were looking in conclusion at the three branches of government that we're aware of in the constitutional system that we have. We have the legislative, executive, and judicial branches. What I'd like to do this time around is focus especially on the legislative branch. Now, we'll tuck in the executive branch as well briefly at the end, but mainly I want to focus on the role, the function of the legislative branch, what we call the Congress. And so we'll do that. But just before we get started, let's have a word of prayer. Our Father, we're grateful to you that you have given to us the great gift of your Word, of being able to study it, to understand it, to be guided by your Spirit and then strengthened by your Spirit to implement its truths in our lives. We thank you that part of the content of the Scripture is the sanction of civil government. And we thank you that we have a constitution, in this country at least, that was rooted in those great instructions, and we pray that we would be sober students as we seek to understand it. We ask all of these things in the name of Jesus. Amen. All right, well, here we go. Right off the bat, if you read the Constitution right past the preamble, we run into Article 1. Article 1 gives us a description of the legislative branch, indicating that the legislative branch has law-making authority. So Article 1, Section 1 begins, all legislative powers herein granted, all of them, that's a critical word, shall be vested in a Congress. Not in the executive branch, not in the judicial branch. All legislative, that is law-making authority, vested in a Congress, and that Congress itself is called bicameral. It has two houses. We have on the one hand a Senate, and on the other hand a House. The Senate is a little bit older. There's a higher age restriction. The terms are longer, and so on. The Senate is supposed to be kind of a stabilizing influence. The House of Representatives, the term of office is much shorter, just every 2 years. That's virtually just a heartbeat, in political terms. Younger people can serve there. You can see already there's a bit of a division of labor even within the one Congress, because one is more aristocratic, a little bit more older, more stable, and so on. The other is more democratic, more immediately connected to the constituency. You can see already there's an attempt to divide authority even within that one branch and to kind of put a balance there. So there will be a bit of a debate going on, as has often been the case, between the House on the one hand and the Senate on the other. Well, the authority of the legislative branch has been created by the people. It was really an extension of that great protest that you're familiar with that took place before the Revolutionary War. No taxation without representation. It wasn't an objection to taxation, but it was an objection to a unilateral imposition of tax by an authority in which we had no right of participation. It was an objection really aimed at representation, or the lack thereof, more than taxation. I know some people think the Boston Tea Party was like an adolescent prank, and maybe it was. I'm not going to rise in great defense of it, but at the same time it was making a point. And the point was that if you're trying to impose upon us a tax unilaterally by an authority in which we had no participatory rights, that violated every charter that was at the basis of our whole colonial experience, then we're going to protest. And that's really what was going on. So that's really the idea, that we have given to the Congress law-making authority, and that authority is therefore to be exercised by the Congress and not by others, because we have this representative capacity, we have this ability to be involved. We can run for office, we can call our legislator, we can be involved in the process, and that for us is at the heart of self-government. Well, if we read this first article, we see in Section 8 of Article 1 what are called the Enumerated Powers. The enumerated powers of the Congress are those areas which the Constitution has specifically identified as areas where the Congress is authorized to make laws. We're not saying that Congress can make laws about any subject at all. Congress has to walk within a fairly tight confine as it begins to be involved in its lawmaking authority. Now, I'm going to mention later we've sort of deviated from that a little bit, and so I'm not saying this is necessarily the way we've pursued this, but certainly the original intent was the idea that Congress would stay within the confines of these so-called enumerated powers. I'd like to just mention them briefly. I'm not going to go into detail in these, but I want you to keep in mind as we mention them how each one of them represents an area of legislative authority for which the states would not be competent to exercise their authority. Each of these represented an area where it took an overarching authority that was above and outside the authority of the states themselves. And that's a very important point because that was clearly in the mind of the crafters of the Constitution. We were trying to create an authority that would be able to, in a sense, tie together these states as United States, but not intrude into the sovereign authority of the states individually. And if you think about these, you'll see that that's exactly what's going on. We have the first one, the power to tax, which of course is necessary to raise revenue in order for the federal government even to operate. But by the way, even then, interestingly, the tax was not a tax directly on the people. It was a tax on the states. The states were required to raise revenue, and then the states themselves would pay money to the federal government. That was the original arrangement. That changed with the 16th Amendment, which of course introduced the income tax, which is a direct tax, but at least originally there was already an attempt to kind of insulate the people from direct taxes, even by a federal government, in which they did have some opportunity to participate. The ability of the federal government to borrow, especially in cases of immediate need and a declaration of war, something like that. I don't think the Founding Fathers envisioned the kind of ballooning national debt that we've taken on, but that's a bit of a different issue. We'll touch on that a little later. The ability to regulate commerce, especially what's called interstate commerce. I'm just going to tell you the Commerce Clause, along with the General Welfare Clause of the preamble, those two have probably been the most important constitutional provisions that have at least opened the door for a vast expansion of federal power beyond what the original Constitution envisioned. So I want to say more about the Commerce Clause in a minute, but right now just to note that the purpose of it was to make sure that all of the states were operating on a level playing field. You know, if one state had, by virtue of economic power or otherwise, some ability to bully the other states, then we'd say that's not a very healthy arrangement. And certainly the whole point here was that the federal government would be able to make sure that each of the states had an opportunity to participate in a way that the game was not rigged, you know, that sort of thing. Naturalization. Certainly we don't want individual states governing this, because you might be a citizen of one state and not of another. We want you to be able to, you know, have one set of rules by which you can be a citizen in good standing of any of the states that make up this republic. Rules concerning bankruptcy. If a person were to bankrupt in one state, we want that bankruptcy to, in fact, have legal effect in another state as well. We don't want 13 individual states having their own rules for bankruptcy. The ability to generate money, of course. We don't want individual states producing their own currency. You know, can you imagine if we had 13 states, let alone 50 states, that each had their own individual currency? That wouldn't be very practical. And so the ability to produce money. Similarly, with weights and measures, if something weighs a pound in one state, we want it to weigh the same thing in another. Adjunct to those, rules concerning counterfeiting, which has to do with money and also with weights and measures. A postal system. We want an efficient system of making the postal works, you know, connect one state to another. And it wouldn't be practical to have every state running its own independent postal system. We want patents to be recognized on the basis of similar rules across the states. Interestingly, you may know that Ben Franklin was the main voice that was militating in favor of this particular enumerated power. He, of course, was a famous inventor, known internationally. Invented the bifocal, the Franklin stove. You know, he's a genius, really. And he never claimed a patent right on any of it. He just did it out of the sheer pleasure of being an innovator. But Ben Franklin understood well enough that if we don't put protections out there for inventors, that it's a really significant disincentive to invest the time and energy necessary to come up with new inventions. And he wanted to make sure that across the states we had very uniform rules that would protect patent rights, and so that is included as well. There needs to be a federal judiciary. Of course, the Constitution itself creates the Supreme Court. That's Article 3. But it was understood immediately that the Supreme Court was going to require inferior courts to serve as a sort of preliminary setting in which cases could be heard and tried and so on. And so we have circuit courts, we have district courts, and so on. We have that kind of court system. The Congress was authorized to create a federal judicial system that would all serve the interests of the Supreme Court, which of course is constitutional itself. The problem of crimes on the high seas, piracy, and so on, obviously this would fall within the sanction of a federal authority rather than individual states. The ability to declare war. We don't want, for example, one state to declare war. We wouldn't want the state of Delaware to declare war against Spain, or something like that. We need to be consolidated at that point. So again, this is an authority that spans all of the states. Connected with declaring war, the Congress has authority to raise a military, and that, of course, is a very important part, to create a navy. Out of that, of course, to create an air force, a space force that we have now, and so on. All of these properly fall within the enumerated powers. Along with that, to create rules for the military, to set uniform standards that the state militia, the National Guard as we now call it, would operate within the various states, to supervise the military. All of these, of course, related to needs that we would have as a nation, as opposed to needs that would fall to the individual states. The creation of a district that would house the state or the national capital, a district that is not a state. The framers of the Constitution was quite clear and very wise in saying that the national capital should not belong to any state. It would give a kind of unfair advantage, to any particular state if it also was the home for the national capital. And so to avoid that, the District of Columbia was created. The silly idea that's floated around recently that we should turn the District of Columbia into a state is not only misguided politically, but is really unconstitutional on its face. But nevertheless, the reason for that is because we need an independent piece of ground, which is where the national capital would exist. Finally, the last of the enumerated powers is called the Necessary and Proper Clause. And this was simply the authorization by Congress to implement and pass laws that would give it the ability to, in a sense, execute these other laws. In other words, provide the means whereby those other enumerated powers could be carried out. Well, those are all distinctively federal authority. States, by the nature of the case, are not permitted to, nor are they competent to, legislate in those areas. They are distinctively federal. They belong to the federal government, and lawmaking authority in that connection is restricted to the Congress. The 10th Amendment of the Bill of Rights was really an attempt to just make sure that everybody got the message, and so in no uncertain terms it declares the powers not delegated to the United States by the Constitution, nor prohibited by it to the states. So anything that is specifically assigned to the federal government, or in the alternative is restricted from the states as an implementation of their power, any of those are reserved to the states respectively, or to the people. The whole idea there is that we've given to the federal government certain powers, but anything that's not mentioned, you see, this would be things like criminal law. I mean, there's all kinds of traffic laws, all sorts of things, various kinds of commercial laws, that sort of thing. All of this is going to devolve to the states. There are many, many more areas where the states have the right and the authority to pass laws than the federal government. The federal government is really quite restricted in the areas in which it is given the opportunity to pass laws. So this is called exclusive authority, the exclusive power of the federal government, and it was considered quite important, really foundational. And it was a way, if I can just say it again, of making sure the federal government did not become too powerful. You see, that's the point. We're saying you can make the rules in these areas, only these, and that in itself is going to be a way of sort of clipping the wings of a federal government which would have a general impulse to grow and increase its power as much as possible. One of the earliest commentators on the Constitution was a man named Joseph Story. He was a Chief Justice of the Supreme Court, a brilliant scholar and a constitutional scholar, writing in 1833 on this point. that is exclusive jurisdiction belonging to in these areas to the federal government, he said, quote, "The first resolution adopted by the convention," that is the Constitutional Convention on this subject, "of the powers of the general government was that the national legislature ought to be empowered to enjoy the legislative rights vested in Congress by the Confederation, and moreover, to legislate in all cases to which the separate states are incompetent." That's the whole point. The states are not competent to pass certain laws, laws of, let's say, printing money. We don't want each individual state generating its own currency. That would be impractical and really would be sort of ludicrous. The idea is we want one authority to do that. Bankruptcy, all of these would really fall within that scope, and that's what Story is pointing out here. Or in which the harmony of the United States may be interrupted by the exercise of individual legislation. If one state began passing laws that would would serve to exacerbate, let's say, the relationships with other states, that would disrupt the harmony. And one of the reasons we wanted a more perfect union than we'd had under the Articles of Confederation was to make sure we could protect the harmony. That was really, in many ways, part of the guiding influence here, and so Story is commenting on that, and it really is pretty clear as we look at the Constitution itself that that's what was envisioned. Is there such a thing as concurrent jurisdiction? Is it possible for both the federal government and the state governments to share jurisdictional powers in a particular subject area? Well, if you just read the Constitution, you would say that probably not, or if so, it would be rare and probably only applicable if the Constitution actually authorized it in some fairly obvious way. I probably don't need to point out to you, however, that that particular principle has been violated in the extreme in subsequent history. So now we find the federal government legislating in all kinds of areas that would really fall well outside the enumerated powers. We have the federal government basically legislating matters of education, let's say, or other matters that would really properly fall within the sanction of the state. This is done by means of what are called federal mandates, in which the federal government says, okay, we're going to give you this much money, but in order to get the money, you have to obey these rules. I think you're familiar with that. It's a way of kind of sidestepping the provisions of the Constitution. It should concern us because it does represent a way of actually sort of avoiding the force of what's being stated here, and gives much more authority to the federal government than was originally envisioned. And so for that reason, I think we'd have to say that Congress has over the years gradually greatly exceeded its constitutional authority. And not surprisingly, this has resulted in a great deal of redundancy, sometimes inconsistency, where the federal government has one rule that applies and a state government has a different rule that applies to the same issue. That kind of thing has happened, and not all that uncommon. It's certainly the principal explanation for ballooning national debt. By far, most of the national debt has been incurred by virtue of this sort of concurrent jurisdiction that we're speaking of here. And I don't need to point out to you that in many ways it has resulted in a practical restriction on many freedoms that American people would otherwise enjoy. So this should concern us. It's not irretrievable, it's not all is not lost, we shouldn't despair, but we should be aware that at this point we've seen government do what government has a bias to do, namely increase its own authority. And that is the very reason that we said we the people create this government, because ultimately the people who created this government are the ones who finally have sovereignty over it in a practical way. And it may be time for us to take that a little bit more seriously. I mentioned earlier the Commerce Clause, the Commerce Clause, the third of the Enumerated Powers, Section 8, Article 3. Well, the third of these is the Commerce Clause. The precise language of the Commerce Clause is as follows: to regulate commerce with foreign nations and among the several states and with the Indian tribes. All right, so it's pretty short and pretty straightforward. The Commerce Clause authorizes Congress to pass laws which would govern international trade. Well, that makes sense. We don't want individual states entering into international trade without really having a kind of consolidated, you might say, single face that represents the entire nation in that regard. Similar provisions apply to the sovereign nations within us of Native American tribes. And so those two are pretty obvious and have been followed fairly consistently. The one where there's been a little bit of difficulty, however, is the one that has to do with interstate trade. Interstate trade is the point. Congress has the ability to pass laws that make sure that the states are all on a level playing field commercially. In their commerce, nobody is able to enjoy a greater advantage legally than any other state, and that's really the limit of it. That's really what the Commerce Clause is supposed to do. Well, you can imagine that Congress, especially some members of Congress from time to time, have had a deep passion, a deep desire to not simply legislate among the states, but to legislate within the states, to somehow be able to reach into the inner workings of a given state and exercise authority there, which would on the face of it not represent what the Constitution actually stands for. There's been a series of Supreme Court cases that have really opened the door increasingly to that kind of activity. I say this regrettably, but the fact is, in constitutional history, the Supreme Court has sort of aided and abetted a little bit of this desire on the part of Congress to exceed its constitutional authority. One of the better known cases in that connection was a case that arose out of the New Deal legislation, you know, back in the days of FDR, in which he was really advocating for quite a bit of legislation that would go beyond the Constitution. But this is a case that challenged a piece of New Deal legislation. The case was called S Versus Schecter, popularly called by lawyers the sick chicken case. I'm not going to bother you with the details of it, but simply to say that Mr. Schecter owned a chicken slaughtering business in New York State. So he's running this business. He gets chickens from throughout the states. They're shipped in by various means and show up in his slaughterhouse there, and so he gets these chickens and slaughters them and markets them, and that's really the kind of business he ran. Well, Congress wanted, for various reasons, to basically regulate the way in which Schecter operated his slaughtering business, and so they passed some rules and tried to enforce them against Mr. Schecter and his slaughtering operation, and he in fact sued on the authority of the Constitution, namely saying that at this point, for Congress to try to regulate the way he did his business was violating the Commerce Clause and the restrictions that applied by virtue of it. And I'm happy to report Schecter won the case. So in terms of his individual situation, it came out okay. But the point is that in this case, the Supreme Court did something which is a little bit cagey, I guess you'd say, but not all that uncommon. The Supreme Court said, you know, that we're giving Schecter the win in this case, but we want to make the point, and this was part of the dicta of that Supreme Court opinion, that any activity within a state that, quote, directly affects or is directly affecting interstate commerce might be susceptible to the idea that the Congress could actually legislate in that area. In other words, in a sense, what it was saying was, Schecter, if you had simply phrased this complaint a different way, you might have lost. You said it in such a way that at this point we're going to give you the win, but for future generations, people, if they just use kind of the right magic language, it might come out a little bit differently. I don't know if you follow what I'm getting at here. I remember this point was sort of dramatized to me in law school once again. The same professor that I mentioned last week who said the Constitution is just another scrap of paper, you know. He also on another occasion, when we were dealing with the Commerce Clause in fact, was talking about the net effect of the way in which federal regulation, federal authority had been expanding over the years. And he was highlighting especially what were called interstate waterways. Channels by which, of course, some states would be connected to others. You know that for many years, one of the principal ways of shipping goods from one state to another would be through a waterway that went through many states. For example, the Mississippi, goes through quite a few different states. Well, that's fine. Congress has the right to regulate interstate commerce using a particular interstate waterway. Well, at a certain point, Congress sort of pushed its limit a little bit and said that that would also include navigable waters. Now, the theory was that navigable waters might somehow still be connected, to interstate waterways, and so it didn't seem to be pushing the envelope that much. And there was no objection. So now we have navigable waters that are included along with interstate waterways. And then a question came up, well, how big does a piece of water need to be in order to be, quote, navigable? And there actually came to be a rule that was passed that essentially said if a bird could land in that water and swim around, it was navigable. Now, I'm not kidding about this. And so all of a sudden, what you have is an extension of federal authority really well beyond, you see, what was originally contemplated as interstate commerce. My law school professor, when he was sort of wrapping up this conversation, made another of his famous one-liners in which he simply said, so everybody, if it's wet, it's federal. See, you get that? If it's wet, it's federal, meaning if it's wet, then it comes under federal jurisdiction. Now, the class laughed because everybody understood that was hyperbole and it was kind of a joke. But it was a joke that was very telling, wasn't it? Because now you see what we have is a situation where that's almost the direction that we're bound to wind up in. That federal authority has reached well beyond the issue of navigable waterways to a very, very different level of jurisdiction. And of course, that becomes part of the way in which federal jurisdiction has been extended. A more recent case was in 1995. This involved a young man whose name was Lopez. He took a gun to a school. This is an area, it's a criminal act, and the state would have facial competence. I mean, criminal acts within a state fall within the legitimate lawmaking authority of the state, and so Lopez was arrested and charged with the crime of taking a gun to school, which was, of course, illegal. But the federal government wanted to get involved in that case, and so they actually wanted to bring a separate criminal charge against Lopez based on a violation of the Commerce Clause, you see. This is how far things had gotten by the time we reached 1995. Well, in this case, the Supreme Court basically ruled that the federal government did not have authority to prosecute Lopez federally, and in so doing it laid out kind of the state of the art in 1995 for these matters. And it said that the Commerce Clause gives rise to congressional jurisdiction if it meets these three criteria, or one of these three criteria. The first one, it has to involve the channels of interstate commerce. Channels are the basically physical means of connection. So these would be things like roads, rivers, airways. All of these are the means whereby the states may be connected to each other. Secondly, the instrumentalities of Congress. These are the devices that use the channels. So these are things like planes, trains, boats, trucks, even a backpack. If you throw something in your backpack, walk across a state line and sell it in a different state, you've just engaged in interstate commerce, conceivably. Both of those are fine. I mean, both of those are well within the parameters of the Commerce Clause. But the third one they allowed in Lopez now, in 1995, gives you a flavor of how far things have gone. Economic activities that, quote, substantially affect or substantially relate to interstate commerce. Now, what's that? On the face of it, you'd have to say that's not a very distinct line that you've drawn there. It's pretty squishy. Substantially affect or substantially relate to interstate commerce. This would certainly allow for, if you're receiving goods that have come by means of interstate commerce, anything you do with those goods, you might say from that point on, could still substantially relate to interstate commerce. And it really does open the door increasingly, of course, to Congress having more and more legislative authority in those areas. And it really hasn't improved much since then. So my point here is not to discourage you, but just to simply point out that even though there was a very significant attempt to try to restrict congressional authority, the Commerce Clause in particular has been a means whereby there's been a fairly dramatic expansion of that authority, and that should at least concern us a little bit. I mentioned to you last week that there's actually two sort of little pinpoint areas in the Constitution itself that have been the areas where we've seen an expansion of federal authority. One is the Commerce Clause. The other one I mentioned last week is the General Welfare Clause. Probably even more than the Commerce Clause, the General Welfare Clause has been used to justify vast spending on the part of the federal government, all in the name of general welfare. I mean, what is general welfare? The framers probably had a fairly limited view of what general welfare is, but you know, the term welfare now becomes a kind of term of art. So you know, you hear the term welfare all the time. Where did that word come from? It came from the Constitution. And so if somebody challenges government spending money on a certain program, if the government says, well, wait a minute, we're just doing welfare, that's what the preamble allows for, then at least on the face of it, it looks like, Congress is still within its prescribed responsibilities. But think of all the things that have taken place in congressional history based on a certain application of the General Welfare Clause. We have various forms of socialized medicine, we have food stamps, we have welfare checks of various kinds to various sorts of people, on and on. It goes on that we have this kind of great financial apparatus working that has to do with welfare. I saw a chart once upon a time, a few years ago actually, that was a pie chart showing the budget of the United States and the money it spends. And I think it was a little bit more than half of the overall budget of the United States was devoted to various kinds of welfare. More than half, or at least around half of the overall budget. That's a whole lot of spending that arguably is outside the bounds of what was originally intended by general welfare. It gives rise to another little point that I'm going to throw in here that may be of interest to you. You know, the Constitution itself actually prohibits what are called titles of nobility. You know that? There will be no titles of nobility. So that's why in the United States we don't have lords, earls, barons, dukes, all of those kinds of titles. We don't have Sir George and, so that kind of thing. We don't have it. All of those are predicated on the idea that there is nobility, that people come into this world, in some cases, superior to other people. Noble and common, aristocracy, non-aristocracy. We don't have that. We have repudiated that. We have founded this republic on a principle that all men are created equal. And we don't have those differentiations going on. Well, part of the reason that the United States took that rule, no titles of nobility, was because we believed in that Reformed tradition that says all people are created equal. But part of the reason was because we didn't want to be paying money to people who claim special status based on a title of nobility. Because in England, that's what it meant. Depending on the title, you were automatically the recipient of certain government expenditures just because you had the title, you see. And that can be pretty expensive, over time. And so we said, as a matter of financial prudence, we were going to just avoid that. In other words, the point of the word title is it gives rise to entitlement. You ever heard of an entitlement? An entitlement is something you get not because you've done anything to earn it, but because you're in a status that can be defined by a title. I'm going to let that sink in for a minute. Do you think we have any people in this country receiving money based on a title? In other words, do we have people getting entitlements? Now, we don't have the titles they had in merry old England. We don't have lords and dukes and barons. We do have mothers of dependent children, single mothers, dependent children. We have all kinds of entitlements based on racial minorities, that kind of thing. We have entitlements based on other sorts of status that a person may find themselves in. In other words, there's a laundry list that goes on and on of all of the titles we have created, giving rise to entitlements. And all of this has taken place under the auspices of the General Welfare Clause. So in a sense, again, the General Welfare Clause has been an end run to avoid what would otherwise be the strictures that we would find there. Now, I'm not objecting in principle, you understand at this point, to welfare, so don't get me wrong and don't misapply what I'm saying. I'm simply saying that to use the General Welfare Clause in this way may be misguided and may be a place where the federal government is intruding into areas that are fully within the competence of the state governments, and that these are matters that would much more efficiently and appropriately be handled at that level. There was actually, interestingly, a debate between two of our founding fathers at the time of the constitutional debates over the extent to which the General Welfare Clause would apply vis-a-vis the enumerated powers. See, these two were already seen as possibly in a bit of a conflict. Sometimes we think all the founding fathers, just sort of shook hands and agreed on everything. They didn't agree on anything. They had lively debates. And two of them, well known to you, debated on this very point. Alexander Hamilton, a little bit more liberal of the founding fathers, believed, now follow me here, that the General Welfare Clause would authorize expenditures that went beyond the enumerated powers if it was something for which only the federal government was competent. You see, that was his view. That's the Hamiltonian view, that there is the possibility of expenditures under the General Welfare Clause outside the parameters of the enumerated powers only if the states were not otherwise competent to handle the same problem. All right. James Madison, more conservative, of course, of the two, said, no, we're going to open Pandora's box here. We're going to limit the federal government to the enumerated powers. That's the end of the conversation. General welfare notwithstanding. So that was a debate that went on at that time. Interestingly, in 1936, there was a case called the United States versus Butler, which expressly adopted Hamilton's view. Okay? So the debate was known to them, and they basically said, we're going to go with Hamilton's view, which permits expenditures beyond the enumerated powers under the auspices of the General Welfare Clause. But, interestingly, Butler didn't mention the caveat attached by Hamilton that it had to be something for which the states were not otherwise competent. Left that out, Interestingly, that is the very case that was relied on somewhat heavily to justify what's commonly called Obamacare at a much later time. Just want you to see how these things happen, So here we have Hamilton's view, sort of modified a little bit in Butler, that now becomes one of the chief arguments in favor of a piece of legislation that came many years later. The problem is, of course, that the use of the Hamilton's view in Butler, let alone in Obamacare, totally disregarded the question of whether or not the states were competent for this. The states obviously had been regulating insurance, including health insurance, for years and been doing fine. But now you've got a point where the federal government wants to step in and assert its own power, and doing so, kind of doing this sort of a little bit of a cagey appeal to one of the founding fathers to make that happen. What Hamilton had in view here was that sometimes there may be situations where the federal government should act for the general welfare where the states are not competent, and in those rare situations, that power could be exercised. That was Hamilton's view. I think the best early example of this would be the Louisiana Purchase. You can imagine the Louisiana Purchase. Napoleon gets on the phone with Thomas Jefferson and says, hey, dude, you want to buy a bunch of real estate and double the size of your nation? Well, no state is competent to do that. That's outside the purview. States are defined by boundaries, and they have to operate within their boundaries, and to buy external real estate was simply not within their competence. It was in the competence of the federal government, but it was not an enumerated power. You see that? And so Hamilton would say, hey, it's fine. This meets my criteria. Buy the Louisiana real estate, and that's good. I don't know that any of us would object to that. Madison, I think, probably would have objected to it. I don't know. He was president after Jefferson, so we don't know what his opinion was on it. But one way or another, you can see that's the kind of thing. That's a far cry from the way in which this rule has been used in subsequent history. The 10th Amendment, of course, was there to prevent this very kind of thing. The 10th Amendment was included in the Bill of Rights as a compromise between the Federalist forces that wanted a stronger central government, the Anti-Federalists who wanted a more limited power given to the federal government, and in a sense the 10th Amendment was expressly provided to make sure there was a balance between those two interests. It was an attempt to make sure the central government was expressly limited in its power. But of course, I think you're well aware that there has been a considerable expansion over the years of federal authority in both of those areas, but especially under the General Welfare Clause. There's a 1941 case called Darby. It was a labor case at the time, in which the court made an interesting statement. This was dicta in the opinion. It wasn't a holding, but interestingly, it's been quoted quite a few times since to sort of, you might say, limit the power of the 10th Amendment, to sort of push it off into a corner and say it's not quite as weighty as it might seem on its face. Listen to the tone of this. This is from the Darby case, 41. The amendment, that is the 10th Amendment, states, but a truism, so it's just a truism, that all is retained which has not been surrendered. It's just a truism. It's like a kind of a working principle in the background, but let's not get too juiced up about it. There's nothing in the history of the amendment's adoption to suggest that it did more than put into writing the relationship between the national and state governments that had already been established by the Constitution. The 10th Amendment is almost redundant, you see. That's kind of the flavor of this. Clearly its purpose was to allay fears that the new national government might seek to exercise power not granted to it, and that the states might not be able to exercise fully the power reserved to them. I'm going to tell you, there's nothing in that statement that's false constitutionally. But the tone of it, you just get the feeling, don't you, that there's just sort of a minimizing of the importance of the 10th Amendment. And that in itself was, in a sense, creating the flavor, the constitutional culture, you see, in which maybe the 10th Amendment could be somewhat given less weight in connection with these conflicts that we've been describing. Well, at this point, of course, the 10th Amendment has almost become a non-issue, as federal mandates have attached all kinds of strings to money flowing from the federal government that govern all sorts of things, education, various kinds of welfare benefits, etc. All of these things, of course, have now become well within the congressional authority, and it's at least worth us knowing that. Whether we think it's good or not, I guess, is a different question, but right now to at least know that it represents a rather dramatic departure from what was originally intended. It certainly has been the case that a variety of policies that one could only call traditionally socialist policies, heavy intrusion on the policy of self-government, all of these have been more or less introduced as a result of this. All right, well, enough of that. I want to wrap up somewhat briefly here with the other branch of government we're going to treat much more briefly, I might add, but at this point, but just to talk about the president. Article 2, of course, creates the office of the president. Just as the Congress has enumerated powers, so the president has enumerated powers. And once again, you'll see that these are appropriate to the office of the president, to be the commander-in-chief of the military. And maybe I could just mention at this point something that is sometimes missed, but it was important to the framers that the head of the military be a civilian. The president is not a military man. He may have been one once, you know, but he's not anymore. He is a civilian, and yet he's the commander-in-chief of the military. The framers were very aware of such a thing as what's called a military dictatorship. They knew the military has extraordinary power because the military is so well armed. And it's possible for a military force to basically dominate a culture at the expense of any of the other political powers that may be operating. And of course, the framers knew that military dictatorships are very, very seldom healthy for the people that live within them. They are considered some of the most horrific kinds of living circumstances that you can imagine. The framers were aware of that, and so they actually wanted to make sure that ultimately the military doesn't have its own life. It's not a fourth branch of government. It can't do anything beyond what the president, a civilian, has given it the right to do. So we like that. I think that provision certainly is an important one and has been an important way of preventing the military from becoming an overly dominant power in American history. The president receives reports from cabinet members. The president can grant pardons, except in the case of impeachments. I think arguably the president could not pardon himself. That question came up once upon a time. The president can make treaties, but notice the treaties have to be confirmed by the Senate. Okay? The treaties have to be confirmed by the Senate. So the president can sign a treaty with someone, but it doesn't take effect until the Senate has debated it and reached a decision and given its imprimatur. The reason I mention that is because the old expression, arose by any other name, you know what that means? Well, in a sense, we are in that pickle ourselves. We have entered a certain number of treaties, but we've entered many more, what are called executive agreements, okay, which as a practical matter are treaties, but they don't require Senate approval. They are actually outside the bounds of the Constitution, but the president has entered many of them, especially in recent years. The reason that's troubling is because it brings up once again the whole principle of self-government. Because some of these executive agreements purport to tell parents how to raise their children, how they should be educated. There's a variety of other areas that are within the scope of those treaties that essentially say that a foreign power in which we have no participation, no taxation without representation, we have no representation, can tell us how to do things that are distinctively internal to the life of the nation, and indeed in some cases to the life of the family. That should be something of grave concern, and we should be really raising that issue as much as we can. Executive agreements that are out there. The president can appoint senior officers and judges, but again, once we need the confirmation of the Senate. You've seen confirmation hearings, of course, on TV. That's where that's going on. Give the State of the Union address, recommend measures for Congress to enact. The president can suggest, hey, Congress, you should enact a law along these lines, and Congress can consider that. The president can summon the Congress to meet. He can also dismiss the Congress when he wants to. He can receive ambassadors, of course. Maybe most importantly is the 10th or the 11th of these, which requires the president to faithfully execute the laws. He's the executive branch, and that's what he does, is execute laws that have been enacted by Congress. And so that's one very important part of his authority. He gives commissions to military types and that sort of thing. So again, we have what amount to enumerated powers. And they are important powers. They're somewhat limited, once again. It doesn't have, total power, but he certainly has significant power by virtue of these grants of authority. Somebody said once, great power implies great responsibility, doesn't it? The presidential power, in fact, has grown considerably over the years. So beyond what's provided for in these powers that are named, there's been a fair amount that has been permitted. You see, it could have been challenged, it wasn't, or it wasn't successfully challenged. One of these would be, for example, undeclared wars. You're well aware of this, aren't you? The last declared war in which we participated was the Second World War. Under FDR, he got a congressional approval to declare war, and we went to war. After that, we had Korea, undeclared war, Vietnam, undeclared war, Iraq, Afghanistan. At the time of this recording, Ukraine is up for grabs, whether it'll become another undeclared war. These are wars in which we sometimes send people into battle. Our young men and women can wind up dead, and they can be just as dead as they would be in a war that had been declared. And yet these are simply taking place on the basis of presidential authorization. Now, there's a significant question whether or not that's really permissible. I'm not going to say these haven't been challenged. There were multiple challenges along the way to the Vietnam War and so on. But as a rule, the Supreme Court simply didn't take it on. And so by virtue of that, the president was given the permission to do these things. We have also significant grants of authority to the president along with what are called federal agencies, which serve under the president, at least broadly. They're part of the executive branch, not the legislative branch. This is the alphabet soup of various agencies that you're aware of. Department of Health and Human Services, the Department of Congress, Homeland Security, the Environmental Protection Agency, the Department of Agriculture, and the list goes on. I think you know that there are just innumerable, well, not innumerable, but a whole lot of federal agencies. And what happens here is that the federal agencies are created by an act of Congress, but they are created as operating under, at least broadly, the president. Okay? So they don't operate under the authority of Congress. They're created by Congress, and then they're given the authorization to make rules to implement what Congress has enacted as a law. Now, sometimes these rules can become extraordinarily detailed and really have the force of law. When I was in law school and taking my first little tour through the law school library, I was looked at the United States Code. These are the laws that have been enacted by Congress. And then, not far away, was another body of literature called the Code of Federal Regulations, the CFRs as they're called. Many, many more. You see, these are the regulations that have been enacted by these agencies and many others, and they have the force of law. In other words, if you're a homeowner, somewhere out in Nebraska, you could conceivably have someone come along under the authorization of one of these regulations and tell you things you can or can't do with your property, and you have very little recourse. You can't call your legislator because they're going to say, oh, well, that's the agency, they did it. But the expense of challenging an act by an agency that basically restricts your freedom, it's an extraordinary expense. It's very time-consuming, inconvenient, and for most people, impractical. So we have really created kind of an albatross here in terms of agencies. Again, I know that's a reason to be a little bit discouraged, but I also want to say I think there's some hope that that may be restrained. In fact, at the time I'm making this recording, I can't give you a definitive comment on this, but I know that right now the Supreme Court at this moment is considering a case which would greatly restrict the authority of these agencies to do the very thing I'm describing. We can be hopeful that the Supreme Court is going to reach a decision here that will in fact have a positive impact. At this point we don't know for sure, but it certainly seems probable that it may be the case. By the time you see this, in fact, we may have a decision on that, so we'll just wait and see. But in any event, we have those alphabet soup, as they're sometimes called, of executive agencies. Executive agreements, I talked about treaties and executive agreements. There's about 900 actual treaties that we have entered as the United States. These have been approved by the Senate, and they represent, authentic treaties. There's about 5,000 executive agreements. These have been signed by the President, but because they're not called treaties, they don't require senatorial approval. But arguably, they also give rise to rules generated by external authorities telling us how to do things inside our country. Not simply among the nations, but inside our country, that can in some cases be extraordinarily intrusive. So once again, we probably want to keep our eye on that and be aware that that's at least a point where there's some significant risk, I would say, to American freedoms. Why does this happen? Why do we have a migration of power among the various branches? Why does that occur? The fact is that when Congress gives away authority, it doesn't actually lose any authority itself. It simply gives additional authority to another branch of government, and in a sense, the authority of both is increased. And this is really, once again, one of those things that I think we're intuitively sensing it, but we don't necessarily put our finger on what the problem actually is. There is a bias in all governments to increase authority, and we've certainly seen that, and the Constitution is our biggest bulwark against it. But it is a Constitution that belongs to us, to we the people, And if we don't raise a voice of protest, who else is going to? And so we need to put the pressure on our elected representatives, question them closely as to their views of these things, and insist that they do what they can to begin to restrict the exercise of this unwarranted authority at the federal level. So anyway, we find this kind of thing going on. Congress gives away its power, in some cases, to avoid political fallout. Often the net effect is to leave private citizens with very little recourse. As I say, the Supreme Court has been considering at least one case that I'm aware of, which may in fact have a very negative impact on this expanding authority of the federal agencies, and we can simply hope that the court does the right thing in that regard. But as I say at this moment, I don't know exactly how it'll come out. But the fact is, historically, the Supreme Court has been somewhat unwilling to weigh in to some of these issues. There were multiple challenges to the legitimacy of the Vietnam War during the time that the war was going on. The court was never willing to hear it, basically saying these are political issues and we're going to stay out of politics and leave it to the political discourse to handle that. So that was one missed opportunity, really, to raise an issue about an undeclared war in which we were involved. There's been challenges to executive orders that have been issued by the president, and again, the court has been quite reticent to get into those conversations, citing executive privilege and sort of letting the president do under executive orders the things that he may want. The rulemaking authority, of course, may be facing a little bit of a rocky road here, as I was saying, but we'll have to wait and see. But generally speaking, the court has not been overly willing to participate in these matters. So anyway, this has been an attempt now to just summarize the first two articles of the Constitution, to talk about what's there, basically the wisdom that went into the original crafting of them, some of the places where we've seen a significant erosion of the standards, the protections that were there, and I hope that's been helpful to you. And next time we're together, a week from now, I'll be uploading the next of these, Lord willing. We're going to be shifting our focus to the Bill of Rights, which is the other place where there's been a huge amount of interest, of course, and looking at some of the provisions that are included there. So that's the direction we're heading next time around. I hope you'll be able to find your way back and participate with us as we take on that important topic next time. Until then, thanks for joining us. Thanks for your interest in these matters, and I look forward to having you with us the next time.